Good afternoon and welcome to the Planning and Regulation Committee meeting today on 20th of July 2026. So we're going to start the meeting with apologies for absence. Do we have any apologies?
I've received apologies, Chair, from Councillor McLean and I believe Councillor Morgan as well.
Thank you. So item number 2, it's declarations of interest. Do any members of the committee have any interest to declare? No, I cannot see that. I need to declare my interest in item number 6. So I intend to step down from the chair for that item, a land of Lane Radley Abingdon, and then Deputy Chair Councillor McLachlan will chair that item. So next item number 3, minutes of the last meeting. So just we have to approve the minutes of the meeting held on 13th of April 2026 as a correct record and to receive information arising from them. Firstly, did anyone have a chance to go through the minutes? Any comments, any amendments? No. Can we agree to accept the minutes as a correct records? Thank you. Thank you.
We also have ones on the 12th of May as well. Sorry, it's not on your notes, just realised. Sorry. Yeah, we also have minutes of the meeting after annual council where we elected the chair and the deputy chair, so we need the committee to approve them as well, please.
Okay, and we agree to approve them? Yes. Thank you. Thank you. So just we received 7 requests to address the committee, and we will take those speakers after the officer presentation, so just for each item separately. Now I would like to introduce item number 5. It's update on Wicklesham Quarry in Farringdon. This amendment it is brought forward to correct and clarify the committee's original resolution, which was made on 19th of January 2026 regarding planning application for the redevelopment of the former Wicklesham Quarry. So the item will be presented by Officer David Meaton. Please.
Thank you, Chair. So, committee, you will no doubt recall that back in January, the 19th of January, the committee considered an application relating to the former Wicklesham Quarry. And this is a very short report, essentially to correct an administrative error in the recommendation put to members and therefore the resolution by members at that meeting. So the resolution back in January was referencing that there would be a traffic regulation order required to secure the raised island crossing. That's on the A420. And the position, in fact, is that a traffic regulation order is not required for such a crossing. A traffic regulation order will, in connection with the application, will be required in time to reduce the speed limit on the A420 from 50 miles an hour to 40 miles an hour, and a separate traffic regulation order will be needed to prevent right turns into the site. Those are separate matters, however. There is not a need for a traffic regulation order for a pedestrian and cyclist crossing over the A420. So in order to get the position straight and correct, we're bringing this matter back to you just to amend the resolution to correct that error, not to obviously open up the debate again about the application, which has already been considered. So just as has been set out in the short report we've done for you, it's not that the crossing will not be considered by the authority going down the line. There will be a Section 278 agreement submission to the Highway Agreements team in due course, as is standard, and that will pick up all details that are required for there to be a safe crossing here. At the moment, you have indicative information. The Section 278 agreement process will provide more detailed information It also requires a road safety audit. So safety is obviously paramount in that situation. So, Chair, therefore, obviously I realise we have a speaker on this matter, but of course, if councillors have got questions about what I'm saying, that's fine. So the recommendation effectively just deletes reference to the traffic regulation order for a raised island crossing. Otherwise, it is the same as before.
Thank you. We will come back to you with questions after our public speaker. And we have a registered speaker for this item, Richard Tamplin. Please, you have 3 minutes and you can start when you're ready.
I'll remind you, Richard, when you have 30 seconds left. I'll remind you when you have 30 seconds left.
Michael, thank you very much. Can everybody hear me, please? Yes, thank you. My name is Richard Tamplin, and I'm a retired member of the RTPI with more than 50 years experience, of which over 25 years was as a planning inspector. Before that, I worked for 10 years in private practice, as well as for local authorities across England and Wales. Since retirement, I've maintained my knowledge of environmental impact assessment case law, especially of minerals development. Hence, as a responsible chartered town planner, retired, I have a professional duty to point out the risks of granting planning permission for this application. The entire Wicklesham Quarry is a site of special scientific interest. It is essential the committee understands this fact. It is not only the outcrop faces which have this status, but the entire quarry floor and walls which are equally protected. This is not mentioned at all in the screening opinion or the committee report. It's vital for both officers and committee members not to confuse or conflate the need for planning permission under the Town and Country Planning Acts with consent for EIA development required by the EIA directive and regulations and related legislation. They are two parallel administrative processes, and they must be followed using their separate procedures and in their own separate ways. Environmental assessment is an investigative process which collects information on the effects of development on the environment and facilitates public scrutiny. It requires those effects to be assessed in an objective, systematic manner based on the best reasonably available scientific information. The screening opinion fails to follow the requirements of the directive and the regulations. There was a complete failure to report the screening process to the committee. Hence, the committee was unaware that screening had taken place, its reasoning and conclusions, nor was an EIA prepared.
30 seconds left.
Hence, committee members had no reason to doubt they had the power to grant planning permission when that was not the case. Article 3 of the EIA regulation says that a planning authority must not grant planning permission for EIA development unless an EIA has been carried out in respect of the development. This means the decision of 19th of January 26, when the committee was minded to grant permission, was beyond its powers. It must be rescinded.
Thank you very much, Mr. Tamplin. That's done. Thank you. I wanted to ask, do any member have a question for Mr. Tamplin? Thank you very much. No questions. Thank you. So now I want to invite you to just ask. So just we can ask questions our officer. Councillor Sergeant, you had a question?
Yeah, it was regarding the what David actually said regarding the recommendation, and it was about the turning right along the A420 onto the site would be prevented. Have we determined how that will be? Will it be a physical measure or will it just be a sign?
I think actually it's probably right.
Yeah, it's probably a right turn out as opposed to banning a right turn in, because I think that's controlled by signals, but it'll be physical measures and an order through geometry.
And secondly, if I may, could I ask David his opinion on the speaker's assertion that we were acting ultra vires by granting planning permission on the 19th of January?
Sure. I'm going to ask David Perham if he'd first like to say that. Sorry, I'm not trying to dodge the question, but David Perham has written to Mr. Tamplin, and so on this very subject. So I think probably best from him first.
Well, we produced a screen, the County Council and officers using delegated powers. Yeah. So officers are delegated powers to produce screening opinions, which is a opinion of the council once it's made as to whether development is environmental impact assessment development or not. As Mr. Tamplin said, we produced a screening opinion and we concluded it wasn't. And a third party, I believe, then, as they have the right to do, sought a screening direction from the Secretary of State, which would effectively be an appeal against our decision, and the Secretary of State responded to say they weren't prepared to do that. So I think that point's covered off in my mind. I mean, I hear everything Mr. Tamplin said. I think everything's been done entirely correctly, and it doesn't affect your decision as of January 19th, unless David wants to add anything.
No, Chair, I support what David said.
Please, Councillor Honaby.
Yes, I did ask me. On the 278s, have we got to have the 278 in place before any construction, or is it after the construction of anything on that site?
Our standard position is that a 278 agreement is required prior to the commencement of development, and there are some exclusions from that which allow site investigations and things like that, and site clearance and what have you. But that's the normal rule, and I'm sure Jason would be able to add, but I'm expecting that would be the case in this.
Yeah, the agreement itself will be expected to be in place prior to commencement of works. So all the technical audit will be in place, highway road safety audit, any audit that's required to implement that 278. So all those bits and bobs will be done prior to commencement.
Do we require them, ask them to put the 278 into play, or will whoever's doing the work put the 278 into play? Because I have an issue in my area whereby we had to ask for the developer to put the 278 and do the necessaries to get that in place.
So you mean submit the submission to technical?
Yes, how early would, yeah.
They will have to submit it. That they will have an obligation to do that prior to them commencing. I understand where you're coming from in terms of there being difficulties in some places. This time they can't actually access their site without it, so they will have to do it prior to commencement.
Okay, thank you very much. Any more questions? No, then can I have a motion, please? Then let me move a motion, just to amend as a resolution is proposed in the officer report. Can I have a vote, please? Those for?
Yeah, just a second. sorry.
Sorry.
Just to say, so just to be clear, just to read the recommendations out, the committee's being asked to that the resolution of the committee from the 19th of January be amended to state as follows: that subject to further consideration of satisfactory highway treatments for the crossing the A420 by highways officers with the applicant and planning officers, which would come back to the chair for consideration, and a 25-metre buffer zone on the SSSI, and subject to a section 106 agreement to cover the matters outlined in Annex 2, planning permission for MW0151/23 be approved subject to conditions to be determined by the Director of Economy of Place to include those set out in Annex 1. So the chair's moved that. Do we have a seconder?
Yes.
Yeah, Councillor McLaughlin. So
Thank you very much. Thank you,
just,
now can we have a vote for that, please? Any against? Any one abstention. Thank you very much. So now I'm standing down, and then yeah.
Bear with us whilst we play musical chairs. Right, so agenda item number 6, the land at Thrupp Park, Bradley in Abingdon, Oxfordshire. The order that we will run through things today are that we will have a recap from David Perriam, because it's been some time since we last all got here together to look at this. We then have 6 speakers who will run next in the order. Those we split evenly between those who are the applicants and those who are opposed, which will mean that the opposed will each get 3 minutes to talk, and the applicants will get 6 minutes each, being just 2 of them. And then it's highly likely that we will then need to go into a private session to receive advice on the latest KC document that has been received recently. So that's the order of play. I will hand over to David Perriam.
Hello again. So this is the second item that was originally on the January committee agenda. I appreciate that not all the members who are on the committee today were here in January. So I think I'll just start off giving a very brief presentation just to remind those who were here and for those who weren't to see what it is we're talking about. So I'll just share my screen. Okay, so we're talking about this is not a planning application. The planning permission, and I appreciate there's views on this, but the starting point for this is as an existing planning permission, and that being the case, what's before you is an application for updated conditions to be attached to that planning permission. This is in line with legislation that was first brought in, I believe, in the 1990s. And this is land at Thrupp Lane, Radley. So that's an ordnance survey of the general area. I don't know if you can see my cursor or not, but it's this general area here. I'm circling my cursor. So we've got Radley Village with Radley Station up towards the top of the picture. We've got Thrupp Lane dropping down southwards from there with the dog leg in it, and then you can see where it becomes a right of way, and then you can see existing lakes. That's previously restored workings, and the land that is proposed to be worked further is to the south of that, but the actual planning permission covers a wider area. So the actual planning permission, which the conditions would apply to the whole of the planning permissions, are what we call DD1 and DD2. So the yellow area is that which is subject to DD1 only, the blue area is that which is subject to DD2 only, and the green is where the 2 where there's an overlap, basically. And then this is one of the application plans. So you can see again the areas yellow, blue, and green, which are the total area of the planning permissions which the conditions would apply to. The area shown in red is the area where it's proposed to carry out further sand and gravel working and gain access to that. And in a hashed red line, I don't know if you can see that, but that's where there is a separate planning permission for a conveyor, which this committee approved a few years ago. So the mineral will be removed by conveyor to the existing Tuckwells processing yard. So it wouldn't be coming out raw, as it were. It would be going out there and then coming out onto the Thrupp lane at that point. So this is basically the proposal that site is worked in phases A, B1, B2, and phase C. So that's just showing the line of the conveyor running up into the Tuckwells yard, as I said. And this is the proposed restoration plan, showing a mixture of restoration to lakes and shallows and reed beds and some planting. And here's a few photographs, slightly more limited selection than I showed originally. So this is on the Sustrans route and also right of way at one end of towards one end of the site. This is looking along the track, and you can see the properties which are the closest properties at Thrupp to the site. So you can see the properties with the roofs and the chimney, and then the working area is the other side of the proposed working area is the other side of the track. This is the track. This was obviously in January when it's very wet, and this is the track which could be used for bringing plant and machinery on, but would not be used for the lorries taking the mineral off site. And this is just moving into the site. Large parts of the site are quite overgrown with scrub and some woodland that's developed over time. So this is just various views within the site. So you can see there's already a wetland area within the site, which is a rich habitat. And this is following the track towards the western end of the site. And again, this is at the western end of the site. So this is looking back now across at the same properties that I showed you in the previous photograph. And then just panning round. Okay, so I think that's all the photographs. So the committee will recall, or certainly those of you that were here, that in February you resolved that the matter be referred to the Secretary of State with a request that he called it in for his own, called the application in for his own determination. Officers sent a relevant letter to the Secretary of State, which had obviously legal input, and the Secretary of State was also asked various questions, which obviously have been raised by those interested in the matter, related to the law around the site in terms of the relevant regulations, and the regulations also about dealing with irreplaceable and priority habitats. The Secretary of State responded. He declined to call the application in, but he didn't give any guidance at all on any of the other questions that the council had asked. So obviously that didn't give us any answers. So in line with the recommendation, given that the Secretary of State didn't call it in, the recommendation was that the Director bring it back to you today for further advice. So you've got the report before you, which is essentially as officers recommending two options: approve the application without the restrictive biodiversity condition, which would mean therefore there was no restriction on the working rights, or approve the conditions with such a condition which would put a restriction on the working rights and would oblige the council to then issue a separate notice saying that to the applicant that that was a situation, therefore they were entitled to claim or entitled to compensation, and I think you were advised on the level of that previously, or the potential level of that previously. Now, there's been further correspondence since the committee report was published, which is in a relatively short addendum, so I'll just read that through. So reputation has been received from Winston Taylor International LLP, that's a firm of solicitors, with an attached counsel opinion from Gregory Jones KC on behalf of a local resident, and that is appended to the addendum in full. Members are entitled to give consideration to the KC opinion provided. However, it should be noted this has been provided by a third party opposed to the ROMP application, whose instructions to counsel as set out in paragraph 3 of the opinion are recorded as follows. My instructions explain that this client anticipates that any resumption of mineral extraction will cause harmful amenity impacts in the local area, and that the client's objective is to prevent the ROMP application being approved. Now, should members be minded to, you could further defer determining the conditions to obtain the council's own further counsell's opinion, and obviously officers could instruct, another barrister could instruct a KC. As previously recorded in the minutes of the meeting on the 23rd of February this year, additional legal advice would be a further opinion to be considered along the advice already obtained by or submitted to the council by the applicant and local residents. It still would not provide a definitive answer to the lawful position. So the officer advice remains taking into consideration the council's own counsel opinion previously provided and that advice and included in Appendix 1 to the committee report. So Appendix 1 has got all the previous report basically with a previous addenda. That the committee can lawfully determine the conditions as set out in the officer recommendation. And then also we had received correspondence from Leyla Moran MP on behalf of local residents. She's advised she has written to the Secretary of State to ask for clarity over whether the issue of the validity of the application was properly considered when it was before him, that is, and what his conclusion was. She's also asked that the Council as Mineral Planning Authority meet with local residents to discuss their concerns and to better understand the interpretation of the ROMP permission. Whilst Ms Moran's comments are welcome and noted, if the Secretary of State was going to provide advice, we would have expected them to do so with the response to the call-in request. With regard to engagement with the local communities, officers have previously met with the Radley Parish Council, who are the elected representatives of the local community, to discuss the ROMP application. Local residents have been able to comment on the application. Their comments have included ones with relation to the point of the validity of the ROMP permission and so the current application. Local residents also spoke at the Planning and Regulation Committee meeting on the 23rd of February and addressed this point before the committee. It's not therefore considered that local residents have not had the opportunity to raise their concerns directly with the committee, and obviously with you as the elected members. Subsequent to the addendum, we've had a couple of pieces of correspondence, one from a third party and one again, well, both from third parties, one from also again the solicitors, Winston Taylor International, still saying they don't believe that the advice we're giving you is the correct advice. That only came in mid-morning, so I've not had time to obviously present you with any written response to that, but obviously Jennifer and I will help you if you've got any questions on that or indeed anything else. Thank you.
Do we have any questions for David?
The codification seems particularly vague with this piece of legislation. Is there any case law at all that can be drawn upon?
There's very little case law on ROMP legislation and the way it operates. If I'm honest, the last decision of this council with the appeal was probably one of the last times this was before any forum of law. So very little has happened on it. There are a few bits and pieces around, but there's nothing that's given us the clarity that one might hope.
Any further questions? Oh, Councillor Hannaby.
Yes, could I ask, please, how many years that we haven't got enough extraction? I think I asked you the question earlier, but I didn't get an answer, I think.
Well, I can't tell you exactly because I haven't got the figures in front of me.
I thought it was, I'm just trying to find it in the report. I thought it was 7 years.
So we have to maintain, or we're meant to try and maintain at least a 7 years land bank for sand and gravel. We are currently below that. I couldn't tell you exactly how much below, but we're definitely below it.
I think that's quite a relevant fact to bring through. Thank you.
Any further questions? No, in which case I will hand over to the public speakers. Do we have Roger Thomas here, please? Hi, Roger. Please turn on the microphone. It's the middle one at the bottom with the mouth with the speaking bit. You had it there, yes. You will have 3 minutes and Jack will very kindly remind you with 30 seconds to go. Over to you.
Good afternoon. You're being offered an unpalatable choice. Approve the application without the additional condition and condemn 12 hectares of priority and irreplaceable habitats to destruction, or approve it with that condition and risk a huge compensation bill. It's a horrible dilemma. But there's good news. The cavalry are coming over the horizon in the form of the legal opinion provided to the council last week by Gregory Jones KC. Mr. Jones is one of the highest rated planning barristers in the country. He's King's Counsel, somebody whose views on the law carry great authority. In 56 meticulously argued pages, Mr. Jones reaches a very strong conclusion that the Thrupp quarrying permissions expired in 2016 and the ROMP application is therefore invalid. You can't put new conditions on a non-existent permission. The council cannot decide the application because it's invalid, and any purported decision on it would be unlawful. I'm a barrister myself, and I've read the opinion very carefully several times. It covers all the angles, including the counter-arguments, in a very balanced way. It's extremely hard to see any holes in it, just as you'd expect from a top KC. The addendum report that you've heard about says that the objective of Mr. Jones's client, a neighbouring landowner, is to prevent the application from being granted. Well, that's the council's objective too. The February meeting was told of unacceptable harm to habitats, and the recommendation then made clear that any approval would be despite this harm and only given because there was not a clear position in law to refuse it. That meeting also heard that the law seemed unclear. Secretary of State's offered no guidance. So for the council, the law was still unclear until last week, that is. Mr. Jones's opinion is game-changing. He makes it as clear as anyone could hope, short of a High Court ruling, that the permissions have expired, that the application is legally invalid. If the committee purports to improve it today, the council is liable to end up in the High Court, potentially paying tens of thousands of pounds in costs. To be fair, Mr. Jones's opinion was only provided to the council on the 9th of July. Officers need time to consider it fully. As a committee, you are entitled to, and actually you need, a fully argued analysis of the KC's opinion and a solid assessment of whether or not it provides the best available interpretation of the law. To reject the opinion of a KC, you need very good reasons indeed. Now, you would be entitled to accept the KC's advice and simply reject the ROMP application today.
30 seconds.
But I think the better course of action would be to ask officers to prepare a full response to the opinion and to bring this to your next meeting for you to consider. And in this way, I'm confident that in the end, the habitats can be saved without huge compensation having to be paid. That's exactly the outcome the council wants. And now we can see how it's possible. Thank you.
Thank you, Roger. Do we have any questions for Roger? No? Okay, thank you, Roger. You could turn off your microphone. Yes, thank you. Andrew Coker, are you present? Good. Hi, Andrew. Can you again go through the process? Middle button on the microphone. You have 3 minutes when you're ready. And again, Jack will remind you with 30 seconds to go.
Thank you. I'm disappointed, David, that you didn't have the opportunity to read out the statement from Winston Taylor, because that just summed up the whole issue perfectly. And I hope that when you go into camera, that there will be the opportunity to read that completely to the committee, because it really sums up the issues. I speak on behalf of the residents of Thrupp. the people whose houses you could see on the photographs there, we're the most materially affected by the proposed extraction. I also speak on behalf of the many thousands of people who enjoy this irreplaceable landscape. What makes us all extremely frustrated is the way that this whole issue has been handled. The government introduced the ROMP legislation to bring certainty and finality to old mineral permissions. What has Oxfordshire County Council done? Create further confusion, set deadlines, which you now say were not deadlines. And then you still claim to have jurisdiction 10 years after the deadline, which of course you didn't set in the first place. Confused? We are. You should be as well. How is that creating certainty and finality? Oxfordshire's handling of this issue, muddying the waters at every turn, has blighted the lives of the people for whom the ROMP legislation was supposed to help. You now have a way forward, seeking as senior a council as the Wickhall estate has done. As a council taxpayer, I urge you to take better advice, as what you've been directed to do so far has led you to this Horlicks. Mr. Jones KC's opinion covers the issue from every possible angle. Like Roger, I've read it many times and can't find a chink in that logic. Mr. Jones could have agreed with your junior counsel, but he didn't, and you should take note of his seniority and experience. I therefore urge you to take further advice at the appropriate level so that eventually we can have finality and closure. And I finish by saying that before I retired, I spent 30 years in corporate communications. I was Director of Communication for Tesco, Coca-Cola, and conflict management at the UN. I give you now the advice I would have given any of my former employers.
30 seconds left.
Get appropriate legal advice, stop covering your backs for all the mistakes you've made, and close the issue down in a speedy and responsible way. In other words, when you're in a hole, stop digging. No pun intended.
Thank you, Andrew. Can you stay there just a second, please, just in case we have any questions? Any questions from the members? No. Thank you, Andrew, very much for that. Craig Woolhouse. Again, 3 minutes and a reminder with 30 seconds to go. Start when you're ready.
Afternoon. I represent Radley Lakes Trust, a charity established in 2021 to conserve and develop the wider Radley Lakes area for wildlife and quiet recreation. Gravel extraction has been a feature of the area for over 70 years, and Thrupp Lake, the main attraction for the local community, is an old gravel pit that was safe from infilling in the early 2000s because of a well-organised local community campaign. Our response to the application, which is wholly within our area of interest as a charity, is based on our expert local knowledge and the Radley Lakes Master Plan, which has weight in the decision-making process due to it being part of the Radley Neighbourhood Plan. 3 points I'd like to make. We are pleased that the county's proposed conditions in Annex 4 allow 4 of our originally 11 objections to be overcome substantially. And we hope a couple more can be overcome through discussion with the applicant should the proposal proceed. We also agree with the assessment by the county ecologist that there will be a significant adverse effect through the loss of habitats. This reflects what many local people perceive and appreciate in their visits to the area. However, we also accept that ROMP conditions cannot unreasonably restrict the economic viability or asset value of the site. So what is our ask of you as a committee? Phase C, which you saw on the plans that David showed you earlier of the proposed excavation, contains Orchard Lake, which the Trust has sought to protect from the outset because of its high environmental and landscape value. This area represents around 15% of the gravel extraction. So protection of this habitat is arguably not a step that unreasonably restricts the economic viability or asset value. So if you do not support option B as recommended by your officers, our ask of you is that when you weigh the loss of habitats with all the other factors, including the statutory ROMP provisions and the financial implications for the council, you support our proposal to protect Orchard Lake by adding to option A the following simple wording and including the following condition.
30 seconds left, sorry.
And including the following condition, no development shall take place in the phase 3 area of work. Thank you.
Thank you, Craig. Any questions for Craig? Councillor Sargent.
Thank you. In terms of in your opinion, what the adverse ecological effects would be, if you just briefly outline what they might be in terms of Orchard Lakes.
The Acmolean Natural History Society of Oxfordshire, which oversees flora and fauna surveys across the county, describes it as one of the best sites in Oxfordshire for dragonflies, damselflies, and other aquatic invertebrates. So some of the dragonflies can only be seen there in Oxfordshire. Lesser Emperor, Red Vein Darter, and Willow Emerald. So I wish I could tell you more about those, but that's not my area of expertise. But those who do know the area do value it. And the local community value it. It's got a great landscape value. In an evening, watching the sun come down over the lake is an absolute joy. So these things can't necessarily be measured, but they are of value to the local community and in perpetuity. Thank you.
One thing that can be valued, you mentioned that Orchard Lake is 15% of the actual aggregate take of the area. Have you got an idea of what that would be valued at, and can you equate that to the value of the?
I think that's for your officers to decide on, not me.
Right. It's just
and for the applicant to provide you with information. 15% is our estimate.
Yeah.
I've not heard. I raised that point at the last committee meeting. No one challenged it, but we can't collect data on the volume of gravel. We can't value the gravel. We can't take a view on the timescale for that. That's more in your technical domain.
But you did say that 15% wasn't a huge amount to actually.
I think the phrasing is not unreasonably restrict the economic viability of the site. Okay. So the site could still be a valuable asset with that reduction in activity.
Thank you.
Thank you.
Do we have any further questions for Craig? No. Craig, thank you very much. Chris Henderson, are you here? Yes, good. Normal story, middle button, bottom, 3 minutes, reminder with 30 seconds to go. Start when you're ready. There you go.
Right. Radley Parish Council are persuaded that the most recent legal opinion provided by Gregory James KC provides a much more convincing interpretation of the law than the county's previous opinion. The original purpose of ROMP legislation was always to resolve long-standing issues rather than to allow long-expired permissions to be resurrected decades later, as the county's legal opinion suggests. However, as the addendum implies that the officers would like you to proceed and grant permission regardless, we do have 2 other points to raise should you go ahead. Firstly, we support the position that permission should only be granted with the inclusion of the condition on protection of irreplaceable habitats. As pointed out by your biodiversity officer, this is a duty under NPPF para 193, OMWCS policy C7 and the VLP1 policy CP46, sorry. This addresses our long-standing view that Orchard Lake should be excluded from the extraction site. These habitats have developed as a result of decades of prevarication by the landowner applicant so to a certain extent they're of their own making. We would also like a change to condition 54. We would like a fixed deadline, we would propose July 2028, for the agreement to the plan for restoration of the JCSL industrial estate. This estate has had a series of temporary permissions since the late 1970s on the spurious excuse that it might at some time in the future be used for processing gravel from the rest of the ROMP site. Under the applicant's plans, there is no intention to make use of this site, so there seems no reason to delay the long overdue planning for restoration. Making the timing dependent on the commencement of extraction merely causes further delay, particularly as that may now be held up by judicial review. We do not want a position whereby uncertainty over the future allows the District Council to grant another temporary permission to replace, grant another temporary permission to replace the one that expired in November 2025.
Thank you, Chris. Do we have any questions for Chris from the members? No. Thank you very much. Can I call Nick Dunn up, please, next? Nick, you have 6 minutes. Again, you'll have the reminder with 30 seconds to go. Do begin when you're ready. Thank you.
Good afternoon, everybody. Thank you for allowing me to speak. I am the applicant's planning agent. We're pleased to see that despite the ongoing spurious late objector representations and the recent KC's opinion, that your legal and planning advisors recognise that the mineral planning permissions are still live. It is, however, vital that you question any suggestion that the recent KC's opinion should trump the legal opinions to your counsel from Nina Pindham. The KC has been instructed by an objector to identify legal flaws in the council's treatment of this ROMP. The KC's opinion is expressly qualified and based on the limited material supplied to him, presumably from historic committee reports. As a result, this KC acknowledges that further documents could require his conclusions to be revisited. In stark contrast, Nina Pindham, who is a highly prominent barrister who specialises in environmental and planning law, who has been instructed by your counsel to advise your counsel onto whether the council could lawfully continue with the ROMP application under the provision of the Environment Act. Nina has had the benefit of your council's understanding of this ROMP planning history and its correspondence and records. Nina has thus concluded that the council was lawfully dealing with the determination of this ROMP. The applicant therefore has a legitimate expectation that this ROMP will be determined today, and you will not take heed to these well-heeled objectors' threats. As I stated in my address to you in February, the ROMP has been accompanied by an environmental impact assessment, which is subject to a detailed third-party scrutiny over 2.5 years. Whilst there has been local objection, each concern has been reviewed in detail where it was material to planning. These concerns have been fully addressed. We're pleased to see that this stance was supported in the February committee report and that further updates are not required for determination. The February committee report also recognises that with the exception of the unavoidable loss of grassland, impacts can be controlled to an acceptable minimum to comply with government guidance and planning policy. This grassland is, however, of only local importance and not subject to a national designation requiring protection, which in part is why the Secretary of State did not call the application in. Legal opinions on the proposed planning condition to retain this grassland have been sought. The imposition of this condition would make the quarry unviable, would conflict with planning legislation, while compensation would be sought. Such a claim could feasibly be estimated to be £8 million. Your July committee report correctly recommends that a decision must be made today using the planning balance to weigh the impact of retaining the grassland against the substantial compensation and financial implications to your council. We also request that further benefits are considered in this planning balance, which includes the retention and long-term management of extensive areas of remaining grassland, the creation of a new diverse mosaic of aquatic and dryland habitats, erection of wildlife boxes, securing the restoration and long-term management of the area to the north, provision of a 600-metre length of new public right-of-way to connect Radley Lake to the Thames, support of the applicant's business and the great weight the MPPF gives in supporting economic development, and really importantly, provision of 1 million tonnes of sand and gravel required to support your council's land bank, which is currently below the 7 years required by government. As required by the MPPF, great weight must be given to this mineral need in your planning balance. This is evident from the appeal decision at Whitecross Farm in May 2026 for mineral extraction in the national landscape. Here, the refusal by your council was overturned in part due to the recognised land bank need for this mineral. In light of the legal advice given, the planning legislative requirements for a ROMP and the land bank need for this mineral, as well as the other benefits I've highlighted today, we respectfully request that you agree to determine the planning conditions today, excluding the conditions seeking to avoid the already consented loss of grassland. Thank you for your time, and I can answer any questions if you wish.
Thank you, Nick. Do we have any questions for Nick? Councillor Sargent first.
Thank you, Chair. Thank you for your input. Can you tell me, you've said a million tonnes of accurate estimate. Do you know what the percentage of fines and coarse materials are?
That's 1 million tonnes of aggregate taken away the percentage of overburden or quality. So that's actually saleable,
So
1 million tonnes.
Yeah, but what percentage of fine aggregates and what percentage of coarse aggregates? You say sand and gravel. So what are...
Well, we haven't actually provided a split in the mineral sand and gravel applications. You tend not to. You seek it as sand and gravel. It's 1 million tonnes. Your land bank does not differentiate between the two grades, so we haven't included that. But I think the next speaker is probably the right person to answer that question.
And can you tell me why the applicant made the application so late in the day?
Okay, going back in history, a long time ago, the previous operator went through the ROMP process. Planning conditions were approved by default, it's fair to say. They didn't work the site. And the applicant now, Tuckwells, took the site on from them. Tuckwells also operate a quarry at Sutton Wick, and the intention was always that we wouldn't progress FRUP until Sutton Wick was close to cessation, which is the point now. This is for a local source of mineral for the local area. Sutton Wick is local to this area. So it was always our intention, or the applicant's intention, that the FRUP wouldn't be progressed until Sutton was close to cessation. So that's the real reason why, and that's very well documented. Yeah.
Finally, if I may, Chair, in terms of what is the two options before us up until today, have been about an inclusion of environmental conditions. What is the difference between the inclusion of the environmental conditions and what you're proposing to do anyway?
The proposed condition would basically sterilise around 87% of the mineral on the site. So that imposed condition makes the quarry uneconomical to work, which is the point you go for compensation. You wouldn't open the quarry just to, to get the bits that aren't covered in grassland. Yeah.
15% of Orchard Lake be so objectionable in terms of the applicant?
From the applicant's perspective, it is one we want to include it. Yeah.
Councillor Hannaby.
Well, it virtually is the same question that I was going to ask, but you're absolutely convinced that you can bring forward the amount that you said that you would be able to bring to, because we are under our land bank, which is very important that we increase our land bank.
Yeah, absolutely convinced. And the important part for my client is who you're running out of sand at Sutton Wick. This is supplying a concrete plant at Frupp Lane to supply Abingdon with a local supply of concrete. At the moment, that mineral is being exported from outside of the local area, which is thus more HGVs, more climate change impacts. So as far as the business is concerned, it's vital, but I would also argue that a local supply for the local area is also as important.
On the subject of habitat, etc., of course, we are all concerned that we do. Is there or will you or can you do anything in this area to help the talking with the residents?
So what we've proposed, we recognise that there's a loss of grassland. There is extensive areas of grassland around the buffer zones. I think we're up to 16-metre buffer zones around the edges. We're proposing that gets put into a long-term management plan for its retention and management. So we actually see that the ecologist who've been working for us actually sees that as a betterment to the existing situation, because if the farmer wanted that grassland could be lost tomorrow, we would suggest it be put into long-term management.
Councillor Roberts.
Yes, back in 2015, you were given a year in which to put an application in, and yet during your answering the questions, you said, well, we never intended to do working on this because we were working on a different site. But having been given a deadline for a year to put an application in, what gave you the feeling that you didn't need to apply by that deadline?
The deadline, and this is before my time, a few years before I took on the site at 2019, when my colleague was dealing with this. From my understanding, the council tried to rescind planning permission. You went for a prohibition order to say that you haven't worked it in so long, we want to take away your right of planning. I don't know the outcome of that. The inspector went on to it said that couldn't be done. The day after that decision was made, a new ROMP notice was issued, is that right? For requiring a new ROMP application. We were given a year to supply that ROMP application. From my understanding, there was an agreement that wasn't going to happen. And then it went into suspension for 2 years. And the council said, if you don't do anything in 2 years, we are going to try and rescind planning permission, which is the process that we went through again. And then throughout this period, it's very well documented that the applicant was going to wait for Sutton Wick to be finished before we progressed the application. So this is the discussion. My client side saying we don't need a ROMP application yet because we're not going to work it for a few years. We then went through a series of committee meetings and we agreed a 2023 deadline, which we then met, which complied with the start of Sutton and towards the end of Sutton Wick. It's not clear, so to say, yeah. Yeah, as I say, most of this, and David is probably better off at recalling this. It's a bit before my time. Yeah.
Any further questions for Nick? If not, let's move on to James, please. Can you turn the microphone off? Thank you. James, you have 6 minutes as well, with 30-second reminder at the end.
Lovely.
Over to you.
Good afternoon all, and thank you for giving me the opportunity to speak to you again. For those of you that know, I'm James Lodge from H. Tuckle & Sons. Since I last addressed you in February, the Secretary of State has considered whether to call this application in and has declined to do so. That decision is significant. It means responsibility for determining these conditions lies solely with yourselves and this committee, which I appreciate is a difficult decision. Nothing substantive has changed since my last address in February. Your office's recommendation stands, which is supported by your counsels and Christopher Boyle Casey's legal opinions, which confirms that the disputed ecological condition would render the quarry uneconomical to work, which cannot be lawfully adhered to in a ROMP application for conditions. The mitigation secured for Area C, Orchard Lake, that's been mentioned, stands. Our commitment to Radley Lakes and working in partnership with Earth Trust and Radley Lakes Trust still stands. What has changed since February is the cost of continued delay. Every deferral extends uncertainty for my business, our employees, the local community. It's the uncertainty that serves no one's interest, least of all the people this process is meant to protect and serve. It also means continuing to import sand and gravel from outside of the local area, which supplies our concrete plant at Radley and Yarnton. And with this, the additional HGV movements and the climate change impacts that come with it. So I therefore respectfully ask that you recognise the Secretary of State's decision not to call this application in and make a decision. Give due regard to your officer's recommendation and your counsel's legal opinion and that legal opinion from Christopher Boyle Casey. And finally, I know it's difficult, but bring this matter to a close today by approving the conditions with the exclusion of the single unlawful disputed ecological condition. I urge you not to defer this decision again. Sorry. Thank you for your time, and I'm very happy to answer any questions you might have.
Thank you, James. Any questions for James? Councillor Hannaby?
Yeah, well, I'll just say again, how can we, as a committee, be absolutely sure that you're going to work this if you do decide to give permission? And can you and will you work along with the residents who are clearly very distressed about the situation? I do know about the history of this situation, by the way, in the council for a long time, so I do understand the background. But we need assurances, and we do need to have extraction, obviously, where we can. So can we have that assurance?
I can assure you that we have every desire, as we've always been very vocal about, even with our engagement with locals, and we do engage with the locals, such as Radley Lakes Trust, Craig, who you spoke to earlier, we meet fairly regularly. I can assure you it is our desire to excavate this mineral. We have pretty much run out of mineral from Sutton Wick. We are now importing mineral from Gloucestershire, Hampshire, Berkshire on occasion. We have no desire to do that and to increase vehicle movements on the road and both the financial and climate impact that brings with it. So I can assure you, and that can be on open record, that it's our desire to work this piece of land.
Councillor Sargent.
Thank you. I think the initials that were used was JCL site or something. Is that correct? Can you tell me more about that and why that hasn't been worked? Or I think that one of the speakers actually spoke to that, so perhaps you can expand upon that and respond to the question, basically.
Sure. I think JCL relates to John Curtis and Son Limited, who were the previous operators of this site. The reference you make to with the earlier speaker, I believe, is in relation to condition 54, which touches on the restoration responsibilities in the northern part of the site that was shown on David's map previously. It's not in the excavation area or the processing area that we have an agreement in place for, but this would tie the responsibility for restoration of that area, which has been an uncertainty for it's someone else's business. I can't really comment on what their plans are for it, but definitely for the local residents and local pressure groups, I would say. Hopefully that clears up.
Any further questions? No, thank you very much, James. Right. This is where, being my first time doing this, I'm a bit uncertain about what we need to do next, because I feel that we need to go through a private session with Jennifer Crouch, our solicitor, just so that we have an informed decision about some of the legalities here. So I am going to request, do we have to vote on this or, yeah, okay. If we could vote on having 30 minutes worth of private session max, and then we'll come back. Councillor Sargent.
Yeah, I'll propose that.
So
Thank you.
just to say that the actual resolution that will be minuted will be that the public be excluded for the private session of item 6, since it is likely that if they were present during that item, there'd be disclosure of exempt information as defined in Part 1 of Schedule 12A to the Local Government Act 1972, as amended and specified below in relation to those items, and since it is considered that in all circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. So I'm saying that you are happy to propose that, and Councillor Sargent is happy to second, or was it the other way round actually? Oh, sorry.
The proposer and seconder.
Okay. What I'll do now then is, if the committee's happy to approve that we go into private session. Agreed. I will ask Raji at the back if you wouldn't mind taking members of the public to the common hall, and I'll ask the live stream to be switched off. So you've got a couple of minutes to get a drink.
if we can just wait for online to be set up, I'll restart the meeting. Thank you. Well, thank you everybody for bearing with us. As I'm sure you're aware, this is a very complex affair. During our break for legal conference, we have come up with 4 possible solutions. The 2 that you are already aware of, which is option A without environmental conditions, option B with environmental conditions, option C being that actually Mr. Jones is correct and that there is no valid application to be made, and the 4th one being that the difference between the polar difference between the 2 sides of lawyers means that we would need to get further legal advice and to therefore defer the decision until such time. Now, during the initial discussion, there was reference made to emails this morning that have been received, and I'm going to ask David to please read those out just to give everybody here the complete picture on that score.
Okay, apologies. I could have read these out earlier. I omitted to. I'm sorry about that. The first one was an email that Mr. Thomas sent. I'm sure he'd be happy for me to read it out. Dear Jennifer, I'm writing to you in advance of the OCC Planning and Regulation Committee meeting on the 20th of July, at which the Thrupp Farm ROMP application is due to be considered. The officer's report rightly says, para 20, that the committee's decision must be lawful. For it to be lawful, OCC must have jurisdiction, and that is disputed. The committee therefore needs to be properly informed and advised about this issue. Any decision which the committee reaches on jurisdiction needs to be properly reasoned. Report, paras 8, 9, risks creating the impression that any one legal opinion on a contested point of law is more or less as good as any other, brackets, as only the courts can make a definitive decision. That is a very questionable proposition. Do you agree that a closely argued opinion from a highly rated KC with specific expertise in mineral planning should be afforded particular weight in the context of discussing whether OCC has jurisdiction to determine the application? OCC's position on the disputed legal issue is very problematic because it leaves some fundamental questions unanswered. I think it would assist the committee if they could be provided with answers to these questions as follows. 1. Does OCC agree that the permissions ceased to have effect on the 1st November 2016, when no ROMP application was submitted by the 31st of October 2016? 2. If OCC believes that the permissions did not cease to have effect on the 1st November 2016, please can OCC explain what legal mechanism allowed the permissions to remain effective after the 31st of October 2016. 3. If OCC agrees that the permissions ceased to have effect on the 1st November 2016, please can OCC explain what precise legal mechanism enabled OCC and H. Tuckwell & Sons Limited to revive the permissions, and on what date does OCC think this happened? If you're able to provide clear answers to these questions before the meeting on Monday, I think this would greatly assist the committee in reaching a lawful decision, including on the issue of whether OCC has jurisdiction to determine this application. I look forward to hearing you. I'd be grateful if communication and answers you provide to the questions above could be circulated to all committee members before the meeting. And
just to clarify, the representations were sent to the committee before the meeting, so they have had them before, but I appreciate wanting to read them out. So just to clarify.
And the second one, which came in, I think it was about 10:30 this morning, from the firm of solicitors that we've referenced previously, Dear David, we have reviewed the addendum to the report committee published on Friday. It is extremely disappointing that the County Council has not responded to or addressed the legal points raised in the opinion of Gregory Jones KC. In failing to engage with the substance of Mr Jones's opinion, the County Council has not provided the committee with a sound legal foundation on which to determine the ROMP application. We provide 3 points in response to the committee report and addendum below. Our key message to the committee is that it should not proceed to determine the ROMP application today. The County Council has clearly not been able to satisfy itself on the question of the validity of the ROMP application, and the best course is for it to take further legal advice. There is no harm in delaying determination while rushing a decision in the absence of a sound legal foundation risks continuing challenge and significant costs to the County Council. Point 1, paragraphs 11 to 15 of the committee report acknowledge the tension between imposing a condition restricting development on irreplaceable priority habitats and the risk of triggering a substantial compensation liability. The report confirms that the County Council holds no budget or reserve specifically allocated to meet such a liability and that its insurance does not cover it. If the County Council deferred determination and took further legal advice on the validity of the ROMP application, it might avoid this dilemma and a significant associated financial exposure altogether. The dilemma only arises if the ROMP application is valid. If it is not, the County Council is not required to choose between ecological harm and compensation at all. Point 2, the County Council has repeatedly declined to engage with the specific legal points raised by objectors, ourselves and Gregory Jones KC's opinion. The addendum at paragraph 3 acknowledges that the committee could defer determination to obtain its own further council's opinion, yet officers have not recommended that course. The committee is being told that the County Council has already taken advice. That is correct, but that advice does not address the fundamental legal and factual questions raised as set out in paragraphs 135 to 141 of Gregory Jones KC's opinion. This is not a matter of differing legal opinions. The committee is being asked to make a significant decision without the relevant legal questions having been answered. In particular, if, as has been implied, the County Council did agree an extension of time, brackets, as required by the statute, with Tuckwell before 1st November 2016, then the committee should insist on this agreement being disclosed. Point 3, Gregory Jones KC advises at paragraph 20 of his opinion that the County Council approves or determines conditions on the RAP, that if the County Council approves or determines conditions on the ROMP application, there would be a real and substantial risk of judicial review, and he concludes at paragraph 152 that any such challenge would have a realistic prospect of success. Members of the committee must be fully advised of the implications of approving the application. Concerningly, we do not consider that the report to committee or the addendum adequately warns the committee of those implications. Approval will not bring this matter to an end. Any challenge would be resource intensive to defend, and if unsuccessful, the County Council would bear both its own and the challenger's legal costs. We firmly request that the committee defers its decision until the County Council has taken further legal advice. There's no harm or prejudice in doing so. We see no reason to rush this decision unnecessarily and urge that the committee not to proceed to determination, as doing so now risks causing significant ecological harm and future financial costs. Please would you pass this email to members of the committee before this afternoon's meeting and confirm once this has been done. If the County Council has any questions in relation to this email or earlier correspondence, please do not hesitate to let me know. Thank you.
Right, so I have one question from Councillor Sargent.
It's not really a question, it's more part of a debate. Do you want to, can I kick off or?
Fire on, yep.
Yep. Okay, I found the argument contained in the Gregory Jones submission very, very persuasive, should we say. However, I do recognise the applicant's agent made a good point that we don't know, and I'm not accusing anybody of any subterfuge, but we don't know from what Gregory Jones KC took his reference from. We don't know what materials he had to hand and so forth. I'm very much minded by the letter that we received, I think it was this morning, that you just read out, David, that we should actually defer to get our own legal advice to see if our own legal advice confers with what Gregory Jones said. If we do defer, it shouldn't be for a long time. We need to defer for a short period of time. whether we have an extraordinary meeting in a few weeks' time once we have the advice from council back, or if it could be put to the September meeting, if that isn't too long to actually ask for. I think the applicant seems to be very reasonable, and I'm sure they would want us to come up with the right answer for them as well as the local population. And my guess is 4 weeks probably wouldn't be too long to ask for council to come back, give us a response, and then for us to come back fully appraised of the legal position that we find ourselves in. Because we have got diametrically opposed advice at the moment. And I'm not a lawyer, and no other member, as far as I'm aware, no members of this committee are planning lawyers. So it would be useful just to get that advice and come up with a really concrete sort of solution to this very, very complex application, which I find extremely interesting, but it has major impacts for that local area.
Do we have any other points or questions that councillors wish to make? Councillor Roberts.
I mean, I was on the committee when the previous legal advice was given to us, and we were told that we could go ahead and determine an application. And then I read this, which tells me I shouldn't have been able to do that. I find that a very confusing position to be in, having been told that that was perfectly acceptable to do that. And also, you know, we were in a position where we were going to be serving a prohibition order. And again, the advice at the time was we should hold that off and not do that. So seeing this, the word that worries me in here is written advice about the discussion of whether we should or shouldn't be able to go ahead and either say that we were allowed to not to stop any applications in 2015 to 16. And there is a big debate about that, and having actually had advice in front of me on both sides, I find it very confusing to say, well, then you should be able to make a decision without further legal information as to where that balance actually lies. So I would prefer to see something, a third party, to actually give us a bit better steer.
Does anybody else have any points on this, or actually given, yes, sorry, Councillor Cherry.
The deferment, but I personally think, given the complexities that we see before us and in the past, that it does go to the September. It gives us plenty of time, just over 4 weeks. Normally you're 100% sure what you've got on the agenda in September, but a decision is going to have to be made, in my view, at that next meeting with proper legal counsel, because looking through all the agenda, it's gone through, then there's another bit of a legal advice. Just like Judy said, it's going round and round, and I am erring towards that we need to get further advice.
Councillor Sargent, you had your hand up first, then we'll come to Councillor Saw.
I just wanted to know if our solicitor Jennifer could actually tell us what would be a reasonable amount of time to get council advice, and I assume that we've got to do this in a reasonable time frame in terms of the applicant, because they've got a business to run, and we've got to give some certainty to them as well.
I would hope that if we sent it to, you know, qualified, reasonable counsel, we should get an answer back within 4 weeks. That requires me and David putting everything together in a comprehensive package and getting it out the door as quickly as we can. But I would expect someone to be able to give it back within 4 weeks. Where are we now? July. I would
Just to say, the committee meeting in September is currently scheduled for the 7th. That would mean an agenda would need to be published on the 27th of August.
Right, that'll be about the time.
So and David, and David would have to get the report ready for that. So just for everyone's awareness.
That's going to be quite tight, if I'm honest with you.
One second, Councillor Saul was first.
Oh, sorry. You say the 27th would be quite tight.
Well, if we're saying 4 weeks to get it back, we've got to get council chosen, picked. We've got to. This isn't something that can just go to any. We need to look at someone that can do it. I would like to be able to say yes. I will do my best to do that. We will know this week whether we can turn it around that quickly. I'd like to think we can. But if we're going to give someone, there's a lot of paperwork to read here. And we want someone to give a properly reasoned decision. I don't want anything fast, and whoever's available, I would like to get the right person.
Thank you, Jenny. Councillor Saul.
Yeah, thank you, Chair. In some ways, I'm quite reluctant not to make a decision today. This has been going on for a long time. However, I think we owe it to everyone to make a decision on the best possible advice and accept the fact that even a further council's opinion may not be definitive, and we'll be back here making decisions on the basis of an imperfect evidence base. But I think we need to do our best to get the best evidence base we can. So I think we should defer for as short a period as is reasonable to get proper advice, and then we need to come back and make the hard decisions.
Thank you, Councillor Saul.
Yeah, well, I'm of the mind I thought we could have made a decision today, but I will go with the flow. But I think we should have been able to make a decision today, and I know which one I would have had. I will keep that to myself, though. I won't be here on the 7th of September, holidays and things. So I'm sorry I won't be. And I think that those that are around here should be able to come back to make this decision, because we're having this roundabout, and I don't think that we should have this again. And we're making this decision purely on the residents bringing forth their own application and her lawyer's advice, which we don't know where the lawyer has got the information.
Absolutely agree with
it's
all
a shame
of
that we didn't have it earlier, and we may have been able to do something about it. So I know, again, it's very frustrating for everybody. But there you are. I'm just remembering that we have a duty to make sure that we have enough aggregate, etc. We have a duty as a county council. So we are really we are deferring yet again, which is regrettable. But I will go with my rest of my colleagues if they wish this.
We just have one final question from Councillor Batstone.
The point, I think. Yes, I think we ought to go with the deferral, and I also think that we ought not to put time limit on it necessarily, but rely on the officers to do it in a timely manner, because we've got to do it properly. So trying to rush anything would be a mistake. Yeah. So if it takes a bit longer, it takes a bit longer.
Thank you, Captain. Councillor Batstone. So therefore,
just quickly, so appreciate what Councillor Batstone has just said on not rushing officers, and I think that's a point well made. In the Constitution under 5.1, it says additional meetings may be convened at other times, or advertised dates may be cancelled or changed by the agreement of the relevant committee at a meeting, or by a decision of the monitoring officer following consultation with the chair of the committee. So it's well within our rights if there's no business, for example, on the 7th of September, that we move that later on so it fits with the timelines. I'm not saying we do that now, because officers we're not 100% sure how long things will take, but it's an option that we have later on, just so everyone is aware.
Thank you, Jack. Councillor Sargent.
I wanted to move that we did go for more legal advice and a deferment on this occasion. I think Ron Batstone is correct. However, we've got to bear in mind that people are running a business. We need aggregates. but we've got to make balances between what is right and what is wrong. And we've got to also weigh the balance between what is environmentally sustainable and what isn't. So if we could move to a vote, Chair, on the deferment and set a date for that meeting so that everybody knows from this point onwards when it will be. And we do make a decision that day. It can't keep going on. This is.
So you're proposing, Councillor Sargent, and you're seconding, Councillor Thierry. Can we therefore move to a vote on this, please?
Absolutely clear. We're not setting a date today.
No.
Yeah.
No.
Okay. Fine. Thank you. Yeah. This can be done through the chair of committee. I appreciate that's Councillor Legova, but in this instance, that would be Councillor McLaughlin that we can liaise with. So we are well within the constitution to set an additional meeting if needed.
Yeah, Jen, it just as long as it doesn't go on and on and on. We you know, the officers have said that okay, the 7th is a little bit tight. But later than that would probably be the 14th or something. Yeah.
So let's say a date in September. Let's leave it to advice from our legal department and democratic services. We will circulate that as soon as we know, and we will make sure that we are quorate, and we'll make sure that we come to a decision on that day as well. So shall we move this to a vote, guys? So who is in favour of this deferment? 2, 3, 4, 5, 6. That's, yeah. Thank you, everybody. I'm voting in favour as well. And hereby ends the meeting. Thank you very much, everybody. We will keep you posted ASAP on when the next date will be.